This is the night shift across Australia on the Triple M network. Paddy Gerard filling in for Luke Boner. If you want to have a chat, the number to ring, 133353. Well, it was yesterday that George Pell, his defence was torn to shred by judges, and he's going to remain behind bars after sensationally losing his appeal, as I said, with a judge tearing apart all of 13 of his defence team's argument. To find out more, to go behind the scenes legally, we've got accredited specialist criminal lawyer Manny Conditsis with us this morning. G'day, Manny.
Good morning, Paddy.
Mate, behind the scenes, it wouldn't have been a very happy camp.
No, I don't imagine it would be. Losing a case or losing an appeal would make the client and the lawyers unhappy. I guess the only saving grace, if you could put it that way, out of it is that in relation to the substantive ground of appeal, and we might come back to that, the decision was 2-1, so it wasn't completely hopeless in the sense that two judges found against the substantive ground, the main ground, but one judge made it clear that, in his view, the appeal should have been upheld, and if it were up to him, he would have entered a verdict of acquittal.
Does he have a right now to appeal?
He does. When I say a right, he can lodge an appeal to the High Court. He can do that if he wishes to do so. However, for the appeal to proceed to any hearing on the merit in the High Court, his lawyers will have to demonstrate that there is a basis for the High Court to grant special leave. So it's not an automatic right, and it's not dissimilar to the Victorian Court of Appeal, in which the appeal was just rejected. Leave was required of that court as well. In the High Court, the term is special leave. Special leave is required before a hearing can proceed, and usually that has got to do with there being some important legal principle that needs to be resolved by the High Court, but not always.
How come it was heard, yesterday's appeal, how come it was heard by 3 judges? Can you explain that?
Sure. In Victoria, and it's similar in New South Wales, the County Court in Victoria, which is similar to the New South Wales District Court and the Queensland District Court, in the County Court of Victoria, if there's a conviction and a sentence, or just a sentence, and a person wants to appeal the conviction and say they're not guilty, or appeal the sentence and say it's too severe, it automatically goes up to 3 judges of the Court of Appeal. So it's not as if, for any particular reason, in this case, Pell got special treatment or either for or against him. It's normal that 3 judges would hear it. And if you think about the reason for it, it's fairly logical, because you've got one judge makes a decision in the county court. The lawyers say the judge got it wrong. All right, well, who's going to hear that? Another judge. If it's just a single judge, even if it's in a higher court like the Court of Appeal or the Supreme Court, it's still only the view of one judge. And when someone is arguing legal technical points, one judge may have a particular view, but you bring 2 judges on to hear it, and that second judge might have another view, but you can't have 2 judges, because what happens if they don't agree? Then you don't get a result.
Yeah.
So then you bring in a 3rd judge, and you go with the majority, which is precisely what happened here on the main ground of appeal. It was a 2-1 decision.
And how long's he got? If he now wants to appeal yesterday's decision, how long has he got until he can make a decision, or he has to make a decision?
Well, really, he should make the decision within about a month.
Right.
Look, it's not. You can still apply for special leave outside of the normal time frames, but you would generally be looking to lodge a notice of an intention to at least appeal, which would hold it for a bit longer before the final paperwork and submissions would be done. But if you come back, Paddy, to the grounds of the appeal by Pell's lawyers to the Victorian Court of Appeal, there were 3 grounds, essentially. I know there were 13 points that were argued and sort of teased out of the submissions of Pell's lawyers, but essentially came down to 3 grounds. The first ground related to the argument that the decision of the jury in convicting Pell was not reasonably open to them. And that's often called the reasonableness ground. The other two grounds were rejected. Leave wasn't given for the other two grounds, so the court didn't even really go into the hearing of the merit. One of those related to the trial judge in the county court not permitting the playing of an animated reconstruction of inside of the cathedral and what certain witnesses said.
Yeah.
The third ground was that there was a fundamental irregularity in that when the trial commenced and when Cardinal Pell was arraigned, that is when the charge was read out to him, it's supposed to be done in the presence, quote unquote, of the jury.
Yeah.
But what happened in Cardinal Pell's case, it was done by audio-visual link, so the jury were in another room. So the argument was that as the jury were in the other room, it could not have been, quote, in the presence of, close quote, the jury, and therefore that was a fundamental irregularity. Again, a fairly technical point, and the Court of Appeal gave that short thrift, didn't even give leave to appeal. So the only argument came back to this reasonableness ground, in other words, whether it was reasonably open to the jury to reach the conclusion that they did. And Paddy, it's important to know with that ground, it's not a matter of the judges thinking, well, we would have entered a different result, we would have acquitted him and therefore they should have. It doesn't work that way.
Right.
The way that it works is that the judges look at the evidence, look at the material that was in front of the jury, look at all the exhibits that the jury looked at and considered, including a view of the cathedral, which took many, many hours, and then consider, well, based on all that material, was it reasonably open for the jury to reach the decision they did? Now, even though the judge, might have reached a different view, is irrelevant. Was it reasonably open to the jury to reach that decision? And if the answer to that is it was reasonably open, that's the end of it. The reasonableness ground is rejected. And that's what two judges thought, which was the Chief Judge Ferguson, a female judge, and also Judge Maxwell, and the judge in dissent who didn't agree, who would have went the other way, was a Judge Weinberg, so
Right.
2-1.
Mate, what about all of these appeals? How expensive is it?
Very. If the litigant is privately represented, as one would presume, obviously Pell was, and one would presume he was paying his own costs, it would be many, many tens of thousands of dollars.
Wow. Well, it's interesting to go behind the scenes. And Manny Conditsis, the accredited specialist criminal lawyer, thanks for joining us this morning across the Triple M network, Manny.
Pleased to be with you, Paddy.